Okay. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Inshallah, today our group we will present about termination of agency in Malaysia. Next slide. For our group, Muhammad Aziz Zulmukri bin Muhammad Sapian, Nur Ashidah binti Muhammad Zain, Nur Aina Najwa Atika binti Rusdino, and me Umar Haris bin Osman. Next slide. For introduction, an agency agreement is defined on the basis of a legal relationship between the principal and the agent, whereby the agent is allowed to operate on his behalf under some cases by the principal and to pay for the service. This suggests that the principal has control over the agent. An agency agreement is considered an agency contract, and it's define the roles for the principal that the agent needs to do. An agent is a person hired and permitted to do some act for another to represent the other person in relation with third parties. Formally, the under the act, whereas the principal is called the one who hires and authorizes the agent perform certain action. The essence of the agency between the agent and the principal will explain the substance of the arrangement. If the arrangement provide for the appointment of the agent for a specified period of time, the agency will come to an end automatically when that period of time expires, and if the agreement provides for the agency to terminate upon the occurrence of a specified event, the agency will come to an end upon the happening of the specified event. Next slide. For the next, the legal authority. Legal authority means any domestic or foreign, federal, state, country, municipal, or other government or governmental or quasi-governmental department, commission, board, borough, court, agency, or instrumentally instrumentality having jurisdiction or authority over landlord, tenant, and all or any part of the premises. In authority, there are two different type of authority, which is primary authority and or secondary authority, and mandatory authority or persuasive authority. Primary authority or such source include the actual rules of law created by a governmental body, constitution, statute, and code from the legislature. Case opinions from the court and regulation from administrative agencies. This material may be generated from the local, state, or federal level. Secondary authority or sources include materials that explain or comment on areas of law such as article, treatise, treatises, treatises, handbooks, or legal encyclopedias. Secondary authority is useful in helping someone understand a particular legal topic or as a means of finding the primary resources since there are often citations in the text of footnotes. Secondary authority is usual, not cited in a brief because it is only persuasive, meaning that the court is not required to follow the analysis. Next, performance by the agent. If an agent is appointed to accomplish a particular task or for a specific purpose, when the task is accomplished by the agent or the specific purpose is attained, the agency will terminate. Revocation by the principal. The authority of an agent may be revoked at any time by the principal. However, unilateral unilateral revocation otherwise than is then in accordance with the provision of the agency agreement may render the principal liable to the agent for the breach of an agency agreement. Any word or conduct of the principal inconsistent with the continuous exercise of the authority by the agent may operate as a revocation of the agency. By agent, an agent is entitled to renounce his power by refusing to act or by notifying the principal that he will not act for the principal. Notice, if the agency agreement provides that the agency may be terminated upon their party serving on the other written notice of a specified duration. Next.
Okay, Assalamualaikum warahmatullahi taala wabarakatuh. My name is Muhammad Haziz Mukri, and I will continue the slide that as shown as below. Operation of law. An agency may terminate by the operation of law upon the occurrence of particular events. The party will be concerned as an individual by death, insanity, or bankruptcy. The party will be concerned as a limited company when winding up a receivership. Creation of agency. Authority is conferred by the principal to the agent. If the agent exceeds this authority, then the principal will be bound and the agent will be personally liable to the third party for breach or warranty of authority. Implied appointment by the principal. The law can infer the creation of an agency by implication when a person by his word or conduct acts as if he has such authority and the principal acknowledge that he was entitled to act accordingly. Implied authority is not specifically mentioned by contract but assumed or implied by the nature of the relationship. Are presumed to be given to an agent if the authority is necessary to perform the duties or responsibility otherwise assigned to the agent or representative. Apparent or ostensible authority. While actual authority arises from an agreement, apparent authority is that which the law regard the agent as having, although the principal may not have consented to the agent having such authority. Necessity. The origins of the doctrines of necessitous intervention by someone who is in a legal relationship with the defendant lie in the principle of the agency of necessity, where an agent went beyond his or her authority by intervening on behalf of the principal in an emergency. The court will prepare to treat the agent as though he or she had the necessary authority to do what was reasonable necessary to save the principal property. If an agency of necessity was established, the agent will be reimbursed for the expenses incurred in the rescuing the principal properties. Estoppel. A person cannot be bound by a contract made on his behalf without his authority. Ratifactions. Agency by ratifications can arrive if an agent was duly appointed has exceeded his authority and if a person who has no authority to act as agent but he had no authority. Notice to the third party. Authority ends only when the third party receives appropriate notice of the termination, when it is no longer reasonable for a third party to believe that the agent has actual authority. Next.
Assalamualaikum. My name is Nak Najib Atika binti Roslina. Conclusion. An agency agreement is a form of general contract. Except where the agency is irrevocable. An agency can terminate in the same way as the contract is discharged. Only the act or consent of the parties to the agency or the enforcement of the law may terminate the relationship between the principal and the agent. An agency shall be believed to have continued, if confirmed to have accorded in the accession of an evidence of its termination until as a period of time has expired in order to destroy the assumption that the agency can be terminated through the act of the party or through the action of the rulers. Thank you.
Thank you.
Macam mana?